Dear friends and family, hello, Pranam. Following is the conversation with Mr. Satyabir Bharti. He is a senior advocate at Patna High Court. In this conversation, among other things, we cover what role does personality type play in the practice of law? What does it take to become part of State Counsel? What are the limitations and opportunities come with that? And why are our courts overburdened, limiting our access to justice? I hope this conversation is enlightening for you. Welcome to this podcast.
Thanks for having me in your show.
Yes, I've heard you arguing before Patna High Court. We'll talk about your cases. Basically, the idea is why we are here doing this podcast is we are here to learn from you, from your 25 years of experience. So before we get into the cases that you have been part of and your insights about the institution and the affairs of state of Bihar, I'd like to start from your background, your career background and your personal background. We'll start in decreasing order in a way that since I've last seen you, you have become a senior advocate now. So congratulations for that.
Thank you very much. Thank you.
And so my first question would be, how did things change for you since you have become a senior advocate?
You see, being designated a senior advocate, it comes with a lot of responsibilities. I find a huge change in myself that now I have to do things in a more responsible manner. Even if I am appearing before a court and arguing a particular case, I have to be more responsible towards the courts. I cannot argue just for the sake that my clients wants to take up a particular point. I have to be cautious enough. I have to be responsible because the court relies upon a senior advocate, the arguments of a senior advocate, that he will talk sense, he will talk more about law. And at the same time, junior advocates, those who have just joined the bar or who have put in 3-4 years of in the bar, they will look upon you. They watch a senior advocate arguing a matter, how they are pursuing a case, what points they are taking. So you are more conscious. Therefore, the things become more difficult once you are designated as senior advocate.
So you are put into a higher pedestal in a way that you are expected to mentor juniors. You are expected to put forth a better argument.
Yes.
But all of these expectations are always on some level tied to a lawyer, no?
Yeah, definitely it is there. Whenever a matter is being argued before a court of law, you have an audience in the form of lawyers and the litigants who are sitting there. Now with virtual court setting in, even court cases can be watched virtually by any person.
Right.
They cannot enter the courtroom and start arguing, but they can be watched. You can be watched. Therefore, you are being watched. If you argue well, you take a matter in the right perspective, then you will be observed. You will be appreciated by the courts, the members of the bar, as also the litigants.
No, what I'm trying to understand is that does this designation kind of signaling for the members of the bar or to the bench that this individual comes from merit, or there's certain expertise and experience that is tied to this individual? Is that so, or there's something else as well?
No, designation means like it is. I think it is more of a honor given by the courts.
Honor. Yes.
That you have put in a certain year of practice. We find your argument to be quite appreciated. You
so it's a kind of recognition.
Good understanding of law. It is a recognition which the court bestows upon you. And at the same time, since it is a statutory provision being designated as a senior advocate, and the procedure has been laid down by the Supreme Court, how a person should be designated as a Supreme Court. So, being designation as a senior advocate is like an honor to a lawyer.
Right.
He has put in many years of the service at the bar.
Right.
So that is
right. Still, the designation Indira Jai Singh case. There were several cases in regards to designation as a senior advocate. Even currently, in the more recent times, also Indira Jai Singh is voicing her opinion that the entire process of designation is not very transparent in a way.
You see, arguments are even to the extent that one should not be designated as a senior advocate.
At all. Yes.
At all.
Yeah.
There is one set of argument to that extent also. Because in fact, so far as I remember, the case started from this only. That why are you designating a lawyer as a senior advocate? Why are you giving some added advantage?
But this does not
Because
come.
You are conferring him a privilege.
Right.
After you designate him as a senior advocate, you are giving him a privilege.
Right.
Why are you? But that is not the idea. The idea is that we are an institution. So a lawyer, when he joins the bar, he is at the age of 25, 26 years. He puts in some serious practice. So therefore, he should get a recognition also from the bar, from the bench, that now he has put in certain years of practice and his understanding about law is very good. And the courts also look upon him to assist them properly. And whenever there is a question of law to which the court also seeks answers, they look upon them, they ask them to assist them in courts. So therefore, the purpose for designation of the senior advocate is for the ends of for the bar only, and
fair
for
enough.
the fair of the justice.
Fair enough. Are you from Bihar?
Yes,
Were you born here in Patna? So you did your schooling from Patna?
I was born in Patna only, and my father, he was from Jharkhand. Now Jharkhand. Earlier it was Bihar only, but after partition, Jharkhand became a separate state. So he was from a very humble background. So, but he shifted to Patna, started his practice in Patna with a senior advocate, and I was born in Patna. I did my schooling in Patna, and then did my graduation in political science from Delhi University, ARSD College, which is one of the top 10 colleges under the NIRF ranking.
Right.
And then after doing my graduation, I did law. And
when did you decide to pursue a career in arts? Like you decided to study political science.
Yeah.
Was the pressure to study science, engineering, medicine wasn't back then?
Not really. It was not really, because my elder brother, we are two brothers. My elder brother was into this science. He was of a science background, and he was doing his engineering.
So you're bringing diversity into family.
So my father always wanted me to join this profession, and initially you will in fact laugh at it. When I was still studying in school, like perhaps it may be I was in class 7th, 8th, he used to call me in office and take dictation for him. Just that I have a knowledge about how things happen in chamber and how things go about, how to go about it. Just he used to give me dictation and take notes and all those things.
Did you like that process back then?
So it is like, for a young boy, it is always exciting that you are assisting your father in something which he is doing professionally.
Part of some serious job.
Serious job. So you feel very good. But I am not realizing that ultimately I will be a lawyer at that point of time. But after I did my +2, he always wanted me to come to this profession and join him and assist him in cases. Because by God's grace, though he had a very humble background and he was the only member in his family who could study and come into this legal profession, he wanted me to join this profession, and ultimately I took political science, because I was told that you should take political science. That is one of the best things to do for a person who is intending to do his study law, intending to do his graduation in law. So I did political science because I was like, it was all set for me. +2, graduation, law, and I joined practice. Nothing else. So I was destined to become a lawyer. There was nothing in between, no UPSC, no civil services, nothing of that sort.
So it was choice of your father and you were assisting him. But did you, have you ever considered yourself as a conformist in a way that you never thought of rebelling against what your family is already doing or studying something of your own?
No, I think that so far as I am concerned, I faintly remember, but I was I always liked the idea when he suggested it to me that I should join this profession.
Sat well with you.
So it went well with me. I said, all right, I will do accordingly. I did my graduation. I joined law. Because at that point of time when I was intending to join Delhi University Campus Law Center, so they started that entrance test. So I was not aware. I was taken aback. I did fill up the form, took the examination.
For the graduation?
For the graduation in law.
Okay.
Graduation in law.
Okay. After your graduation?
After my graduation, then
LLB.
So they had this entrance exam. So I sat in that entrance exam without any preparation. Fortunately, I could make it. And then I did my law from Campus Law Center.
Were you always a good student?
Yeah, so far as law, when I joined law, I attended all my classes. I seriously took notes in the lecture hall, and I studied in the evening, during evening time also. And I was serious during my law profession. I was very serious. Graduation, it was okay sort of thing, because like in Delhi University graduation, if you are doing arts, so it was all set pattern. Question 5, you have to mug up 5 questions. And then vomit it in the examination hall. But when I joined law, I became very serious. And I used to attend all classes. And I would advise all students who are doing law, they should attend classes, because it helps you a lot. Because ultimately, if you are intending to join this legal profession, you have to be aware of the provisions of law, the constitutional provisions, what are the problems which one faces. Ultimately, you have to read the judgments. Ultimately, you have to read the statute books. So if you do not read at the time when you are studying law, ultimately, when after you join law, you will have to spend the same amount of time to understand the things. Yes, you will ultimately do it. That is not a problem, but you are wasting your time when you are and when a professor, or we had very good professors in Campus Law Center. And when those persons, those legal luminaries, they are giving you an insight about the legal aspects, then one should certainly attend the classes and grasp whatever is being told in the
good college certainly plays a role.
It plays a good role, and one should be serious during his.
But you studied law from Delhi, and then you made this decision to come back here in Patna and start your practice.
That was a tricky decision, because I did my graduation and law from Delhi University. So for around 6-7 years I was in Delhi only. So coming back to Patna was like, I was thinking about it, whether I should stay back in Delhi and continue to take up this profession in Delhi.
Because Patna would not have been the same which is today.
Like Delhi is of course the capital of the country. It is quite a different place compared to Patna. You get much better opportunities as a lawyer if you practice in Delhi. The scope of growth is more if you are in Delhi. But still, ultimately, since my father was here and he wanted me to assist him in the legal profession, and since we were only 2 brothers, and my elder brother was already in his service, and therefore, in order to join my parents and to stay with them, I came back to Patna and joined the legal profession.
Right. No, what I wanted to understand, that like I understand from your experience that college certainly plays a role, and I am with you on that because I completely believe that. But there's also one element to it, that for this profession you have to be committed to a place for practicing law, because if you are not committed to a place, if you keep on switching from one place,
that for a lawyer, that is a disaster. I think that would be quite suicidal. That is quite suicidal for a lawyer.
So my question, what I wanted to understand was that does this provide some kind of advantage to an individual if he also chooses to study law from the city where he intends to settle or practice law? Because like how you said, 6-7 years in Delhi, again moving back to a new place, then
you have a point there. Right. But at that point of time, when I was doing my law from Delhi University, in Bihar we had only Patna Law College, and so far as I know, that was in a bad shape. Till today, I think it is in a bad shape. We did not have this Chanakya National Law University in Patna. It came very late. So if you have an option of a good law college in your home state, then one should definitely try to get into that law college, because you have a feel of the state, you get to know people, you meet people, and by the time you join profession, you have certain a set of people who knows you that you have become a lawyer and you have joined the profession. Instead of, you have a point there, but
because what I understand is, and I did not understand back in my law school, what I understand is that this profession, at least the practice side of law, a lot you learn from practice, from doing apprenticeship, from being part of this office that you are part of, from learning from your senior. A lot gets transferred from there, because and it is more important even in contemporary times, because you must have read the news when Supreme Court has made it mandatory for 3 years for a recent law graduate as an eligibility criteria to appear in judicial service examination.
Yes.
So what are they trying to highlight? What problem they're trying to highlight? That, look, this is the profession in which the blood and soul you only learn by practice and not through books in a university. So in a way, I see this decision as an that they are trying to undermine the importance of college education, or college education has to be strategically decided in a way that where you intend to settle and practice law, that city, you should be part of that city.
No, that I don't think that is the idea. Actually, when you had pointed out this, I was a lawyer from the Patna High Court also for a considerable period of time. There was one case. At that point of time, the Patna High Court had made a rule. Every High Court has a separate set of rules for appointing judicial officers. So the minimum entry point age criteria was 22 years. But one could complete his law by 21 years. There was a candidate who had completed law at the age of 21 years. So he wanted to fill up the form, and there was no provision that you should have this minimum years of practice. And then he filled up the form and he challenged the provision that if you do not have this criteria of minimum years of practice at
then
the bar,
this 22 years
then what is the rationality behind this 22 years of years age? And then it struck to me that if a person is becoming a judicial officer, is becoming a judge, he is deciding important cases, and in fact his orders can affect the liberty of a person, personal liberty and freedom of a person also. So he should put in a certain years of practice, because experience definitely matters. As a lawyer, you have to be experienced before you, like we have High Court judges who directly join from the bar. The Constitution provides that he should put in minimum 10 years of service, practice at the bar. Similarly, even for appointment of a senior advocate, you should have minimum 10 years of practice. So there is a purpose behind that. Constitution says that you should have some practice, minimum years of practice. So therefore, even for a judicial officer, you should have some minimum years of practice. Just because you have done graduation in law and you have the minimum eligibility, you fulfill the minimum eligibility criteria, that should not be sufficient enough to become a judge or judicial officer.
Do you think wisdom dawns upon an individual in by age?
Definitely. Age definitely matters. And it adds on to that, because if you are working, if you are into serious profession, then with the passage of time, you keep on learning and you absorb things. And therefore, wisdom definitely dawns upon you. You become more mature, you become more...
And I also believe that until you are in a university, you are in the confines of these four walls. Okay, you are learning from books, but books have its own limitations. You are not really present with the lived realities of people, which can only be learned once you are in the field, working, doing some job. What do you think different people are different by nature, and someone could be highly introvert, someone could be someone will have a lot of extroversion to them. So this profession, I see, practice side of law, I see it is both an intellectual profession where you require IQ to sit and read, and that's a lonely endeavor which requires, and your introverted skills help there. But there's also the practice side of it, where you have to meet people from where your clients would come.
Right.
So when you have to meet people, your extroverted side also has to come, and there your EQ plays a role. So according to your experience, what matters more in the practice of law? If one has high on introversion, does that come as a disadvantage?
For this profession, one should not be introvert, number one. But every person has a different personality. So he has to groom himself accordingly. He has to overcome his shortcomings. So if you are an introvert, you should try to get over that. You should not be in your comfort zone. If you are in your comfort zone and you do not want to get out of it, it will have a disadvantage for you. Like a person should not be overtly extrovert also,
right,
so that he becomes very loud.
That
I don't
has
think
its own disadvantage.
for a lawyer, he should not be very loud, and at the same time he should not be very introvert. He should definitely shun his inhibitions, but he should not be too extrovert or overtly loud. He should, like, he will keep on talking, he will keep on speaking, but he should only talk sense. He should talk in a limited manner, but he should not definitely be introvert. He should go out and meet people, express himself in a right manner, but he should not go on to the extent of talking nonsense.
How do you identify yourself?
Like, basically, I am an introvert person. I have a lot of inhibitions while meeting people, and particularly when you are in a formal set of situation where you have to meet people formally. So I like to be confined to my chamber, preparing for case, reading judgments, and doing some research work. And
all those things you genuinely enjoy.
That is my comfort zone.
That is your comfort zone.
Like, if you tell me that you sit in your office for 12 hours at a stretch, I can do that.
Okay.
I have a very good stamina in my chamber.
Right.
But if you tell me that please go and attend a particular formal ceremony, so that, like, irritates me, and I start feeling that it will disturb my entire routine. I would be like, what will I do in the evening? How will I argue my cases on the next day? So then it becomes very jittery. I become very jittery at that point of time. I'm basically introvert, but I don't think this is a good thing for any person. If you have this problem is there, you should try and overcome it. You should get out of your comfort.
So how do you overcome?
I'm still not able to, but I still try.
What worked for you?
You actually, you see, the problem is the thing which has worked for me is that I kept on getting good cases. And I was always busy in my profession. In fact, at one point of time, I was extremely busy, that because I had even joined my senior when he had become additional advocate general. So I had joined him also. And I had a good private practice also. So it became very difficult for me to manage both the things. So ultimately, when I left his office also, so I had a very good practice. So because I was very busy with my profession, so it worked for me. I did not create a problem for me, this my being introvert or having inhibitions.
So you did not have to go anywhere, your work.
But you see, if you meet people, if you have interaction with them, it is not always for a purpose. That why are you interacting with him? It is not that you want to get something from them, or you want to have some advantage from them, some benefit from them. Like, when you meet people, you understand them. You get their point of view also. You get an idea that what they think about a particular subject. Like, your horizon widens. You learn from them also. Therefore, one should be like, for this profession, you should be extrovert, but only within. You see, in this profession, the main thing is that you have to understand when not to cross the line. You see, it is a very thin line, but you have to be very steady. You should not go wayward out of the box, and you should maintain a particular decorum wherever you are. So You see, it is called a private practice. It is not a job, it is not an assignment. You are not bound by any particular set of rules which are service employees bound. But you still, being a lawyer, it is a very responsible thing. You have a responsibility towards the society, towards your clients, towards the court. And the moment you transgress, the moment you become unethical or do wrong things, then you see entire legal system, you are putting the entire legal system at risk. So it causes a lot of harm to the legal system if a lawyer is not behaving properly or not conducting himself in the rightful manner.
Can we objectively answer this question that who is a better lawyer? Like, which personality types make a better lawyer?
Gautam Buddha always said that middle path is the best path. So even for a lawyer, one should not middle path is the best path. You should not be extrovert, you should not be introvert. Middle path, you should try to be speak.
That is the idea of growth. You
that is the
try
idea
to
of growth.
balance yourself.
Exactly. When you are required to speak, you should definitely speak. You should not be very silent about it, and you should express yourself. But you should not be go overboard about it.
You said that naturally your personality allows you to sit quietly and study. You can do that for hours.
Right.
What do you hate? Client meeting?
I hate as a...
maybe hate is a strong word, but what?
Too many cases.
Too many cases.
You see, in Delhi, I find my friends, when I meet my friends, they in a day they are doing 1 case, 2 cases at the most. But they are managing with those small number of cases because they are paid more. And they can demand higher fees. But in Patna, being in Bihar, the fee payment capacity of clients is much less compared to other states.
So volume
increases. You have to take much more larger number of cases. But in my years of practice, what I have felt that having large number of cases ultimately affects your performance in court.
Quality
deteriorates, and you are not able to assist the court in the right manner. And but if you have less number of cases, therefore every evening when I am burdened with reading 5 files, 6 files, then I get irritated. So therefore, but what can one do? One has to carry on with the same. Like judges, if the judges would also like that they should have lesser number of cases to decide, so that they can decide well, pass good judgments. But they are overburdened with, even for rate matters, they are on their board, they have 100 cases. What they will do? They are also under extreme pressure.
You have had your private practice. You have also represented state board, and you have also represented Union of India. So can you tell us that how does one become state lawyer? What's the process like? Do you have to have certain number of years in the profession? How does that work?
As a guidance to young lawyers, what I would say that one should have a delicate balance of both the sides. You see, joining the state it is quite possible for every young lawyer. And currently, during our time when we were quite young, the junior lawyers were paid hardly a very meager amount to sustain themselves. But presently, young junior lawyers, they are being paid a good amount
from the state.
By the state. By the state, like if I am allowed to say that they can a junior lawyer could earn about 60,000 per month. Junior lawyers who has like minimum 2-3 years of practice, if he is able to join any state council, he can earn about 40,000 to 60,000 years every month without any
private practice.
Private. But during the times when we were junior lawyers, you could earn only 7,000, 8,000 rupees maximum, or 10,000 at the max.
Even when you are attached with state?
Only when I'm talking about being attached with the state. So initially, entry point for a young lawyer in the state is becoming a junior lawyer. Entry point, when you have put in 2-3 years of practice, you can join the state as a junior counsel to any state council, because they are allowed to, like government lawyer is allowed to have 4 state junior counsel. Additional advocate general or advocate general, they are allowed to have 6 junior counsels.
Okay.
And then after putting certain years of practice, like 7 years, they can become state counsels in the state of Bihar or in the particular state. But if you want, you have another option of becoming central government counsel also. So that appointment is being done by the central government. For every state high courts, they are appointing lawyers. For you can become a central government lawyer also. There you are paid handsomely. And then they have this tribunals also, central administrative tribunals. They have their lawyers for central administrative tribunals also. Then we have many board corporations. Every board corporations have their own panel of lawyers. They can join those corporations. But you see, the problem, what happens is that if you join a state and you do not have any private practice, because if you become a state counsel as a junior if you become a state counsel, then you cannot practice on the private side.
Okay, that is the bar.
That is the bar. You cannot appear against state government if you become, and that one, if one has joined the state, he should make it a practice that he does not take up any cases against the state government.
And that's a statutory bar or a matter of practice?
Statutory bar.
That's a statutory
bar for a lawyer, but for junior counsels that is not a bar. Okay. Because they are not given any retainer fees, etc. They are only paid a particular amount for appearing in cases, assisting their senior counsels.
Can you represent state and union both at the same time? Can you
one can become. That is not a problem. Okay. But you cannot appear against the, like I am a senior standing counsel of the government of India. I cannot take up cases against the government of India or its functionaries also, like its corporations, its any other statutory body which is central, which is a part of the central government. So I cannot appear, and one should not take that risk also. That is unethical. Because you are representing, and that is a statutory bar also. You cannot take up cases against the government if you are a government lawyer.
But you can represent state of Bihar?
I can represent the state of Bihar, but I can appear against the state of Bihar.
Not against. Can you represent any of the board in state of Bihar?
Yes. I can represent. Because they are again government bodies.
Right.
They are again government bodies. I can.
But again, you cannot take any case. Similarly, you cannot take any case against state of Bihar.
No, I can take up case against the state of Bihar. You see, they are central government, state of Bihar.
Right.
Like if you are a central government council, you can not take up cases against the central government.
Right.
But and at the same time, if you are a state government council, you cannot take up cases against the state government.
Right.
So this is the bar. But it is not like they can take up cases against the central government. And the central government council can take up cases against the state government. But if you have become a counsel for like I am counsel for the examination board or the commission, so I cannot take up cases against them.
Just this board or
just this board?
Just this board, not the state of Bihar in general.
Not state of Bihar. Okay. I can take up cases against other board corporation also.
Okay.
I am a lawyer for a particular board, so I will not take up any case against that board. But I am not a lawyer for other boards.
Right.
So I can. Why cannot I can definitely take up cases against that board corporation because I'm not their employee, na?
Right.
So I can take up that.
And for Union of India, it's Union of India, irrespective of any departments.
In Union of India is like entire statutory body. Like if somebody is a lawyer for the state of Bihar, is representing the entire state and its instrumentalities also.
Right.
So they cannot take up cases against any instrumentality of the state government.
Right. In all these different cases, what role does intellectual and moral independence play? That you might have certain inhibition in regards to a case that it does not sit well in your moral compass, or you intellectually feel that there's no merit in this case. But since you are representing either state or individual, you are compelled to represent them. So how does one balance?
You see, I'll answer your question, but before I'll just come to the previous question once again. I could not. I wanted to make out a point here. You see, for every lawyer, because if he joins a state, it becomes a very convenient thing for him to do. If he is able to join a state council or he becomes a state government, it is a convenient thing to do because cases come to him automatically. You are representing the state, but you are not having the feel of the private side. You are not having the feel of the private side, that because the nature of preparation becomes different. When you take up case for a private individual, you have to listen to him, you have to understand his problem,
Right.
you have to make out whether he has a legal point or not, which could sustain in a court of law. And then accordingly you prepare a case for him. You prepare a petition for him, present that petition, to complete all the formalities for making the case ready before the court, and then you finally prepare the case for arguing before the court, and the other side is there. Somebody uses it like when you are appearing on the private side, you have to like blow a balloon. You have to like, but when you are appearing for the other side, you have to just spin the balloon. That is a big difference. Because if you are appearing for the other side, then you have to just point out one flaw in his argument or one flaw in his case, because every case definitely is not a perfect case. He will have some demerit here or there. So they can always point out, kindly see, therefore the adjudication, you see the judges and the utility of the judges comes, that they have to balance things out. Every case is not a perfect case that yes, this will be the only result. It could be both ways, but they have to balance all the situation and all the things, and then they have to take a decision. Therefore, if you have joined this profession, you should definitely have a feel on the private side. You should have cases on the private side, so that you can balance very well your every aspect of law. Like I was quite fortunate that I had cases on the private side also, and at the same time I had done cases for the government side also. I represented many board corporations. For more than 11 years, I was counsel for the Patna High Court. And I was appointed by Justice Rekha M. Doshit, who was then Chief Justice in 2013. So she appointed us as a High Court lawyer, just being impressed on our appearance before her courts. She called us and she appointed us as Patna High Court lawyers. So you appear for the government body, High Court, you have a feel that how they function, how things go about it,
on
what
the
are the
administrative
problems.
side you learn a lot.
From the administrative side. So accordingly, I appeared for many board corporation also. But therefore, there was a delicate balance. One should not be like totally get swayed by on the government side, and like if you are on the government side, you don't have to get cases, and because cases come to you automatically.
Right. Even in this case,
department.
once you are appointed as a Patna High Court lawyer, you cannot take up cases on the private side?
I cannot take up cases against the Patna High Court on the private side.
Okay. Otherwise, other cases you can?
Other cases.
Got it.
So for 11, 12 years, I did not take any case against the Patna High Court.
So Mike, coming back to the question that I asked, that for your private practice, your private client, you can counsel your clients, you understand what are the legal issues involved, and you give your opinion on the basis of which they have to take the decision whether or not they want to go ahead with the case.
You see, my point of view, that there is one line of thought which says that it is the courts which decide cases. You have to argue cases for your clients, and if the case has no merit, the court will ultimately dismiss that case. But my point of view is that if a person comes to you with a certain set of facts, and if according to you that person has no case,
and here person also means state.
State also. State also, because you see, state is called the biggest litigant.
Right.
As of now, the state is called the biggest litigant. In every case, if they are on the losing side, if they are lost the case, because on the original side, state rarely files a case.
That is why I wanted to understand that what really happens when state is a party. Are you compelled to, just because you are you are on the panel or on their panel?
See, I have never represented the state of Bihar because I have never been a state of Bihar lawyer, but I have appeared for board corporations of the state of Bihar, and I am still their lawyers. I'll just tell you that because if you are a state department lawyer or a board corporate lawyer for the board corporation, then after a case is filed, the brief comes to you, if it is allotted to you, then you are aware that this is the case which the petitioner has filed. You have to defend this case,
right,
as a lawyer for the corporation or the board. And after going through the records, if you feel that petitioner has got a very good case and it is the board corporation which has done a mischief, or it has missed out on something,
some omission
is there, it is not intentional. Generally, what I've seen, that act of board corporation, that is not intentional generally, but they at times they miss out on certain aspects because they are overburdened.
Right.
They are always overburdened. So if they are missed out on, I immediately advise them that you take remedial measures. You rectify the position. Do not invite an order from the court.
Right.
You try to rectify the position before the matter is taken up. Or even if the matter is taken up, I take an adjournment and advise them that you should take the remedial measures. But still, if they do not do, I tell them, you do not have a case. If you want to appoint any other lawyer, you can do so, or otherwise you can tell whatever be the fate. That is the.
So when you do this, how often do they act on your advice, or do they insist on litigation?
No, so far as, because I am quite fortunate that they take my advice seriously.
Okay.
They take my advice seriously, and generally they act on it.
Okay.
They take remedial measures generally.
Okay.
Even while filing an appeal, I do not advise, if the file matter comes to me, that please file an appeal in this matter. I advise them that if they do not have a case, I tell them that you have no case, you should not file it, you should comply with the order. But still, if they want to file an appeal, they have their own panel of lawyers. They can do so by engaging some other lawyer.
Who generally has the power to decide whether to take remedial measures or to go for litigation? Like in the board's example?
Board corporation, the head of the department, like if there is a commission, then it is like chairman is there and members are there.
No, like do they have internal in-house lawyers whom you communicate with, or directly to the chairman?
No, directly to the chairman and the secretary.
Okay.
Directly to the chairman and secretary.
So they take this decision.
They take this
whether
decision.
To take remedial action or to go ahead with
They can seek legal opinion of their retained counsel also.
Right.
And on that basis of the legal opinion, they can take, but they are not bound by the legal opinion also. Right. They can take a contrary decision, even if it is an opinion of the Advocate General, it is not binding upon them.
No, it's not binding. Final decision the chairman has to.
It is the decision of the authority itself. So they ultimately take a decision what is to be done in the matter. But they should avoid, like these days there is too much of litigations, and the problem is that comes with, if you file a case, it does not come with any responsibility as such. Right. What will happen? I lose the case, then I will comply. But
like how clients are individuals are risk averse, because they could see that when you go for case, when you fight a case in litigation, there's some cost and time attached to it. But these state bodies, they run on public exchequer. So they are not risk averse at all, at least in my understanding.
Yes, you are absolutely right on this point. You see that therefore it is called, the state has become the biggest litigant, because a person, when a state body or an authority takes a decision that we should file an appeal. Generally, they are filing appeal. They are not the original parties. If they suffer any judgment, any order from the court, for no reason, they decide to file an appeal. Instead, but
So in the paperwork, there's no compulsion to that regard that they record the regions why they are going ahead.
Absolutely not. It can be a one-line order.
Okay.
That prefer an appeal. Why don't? And you see, the problem is that they say that if we do not file an appeal, somebody will say in future, if there is an audit or some higher official, they will put a question. They will issue me a show cause that why did not you prefer an appeal against this order?
So there's incentive to them to go for appeal.
There is a reason for them to go for an appeal, but that is not well founded. That is against the state litigation policy also.
Right.
You see, every state has their own litigation policy. The courts are being overburdened with cases because of this reason. I am not blaming the state alone. Even the private parties, both of them are responsible for overburdening the courts with litigations which are absolutely unnecessary. Because when anybody, be it the state or a private party, if they are filing a case, it does not come with any consequences upon them. Consequences other than losing a case. But if this consequence apart from losing a case is fastened upon them, they will be very skeptical before filing a case. They will think twice over that whether we should go with this litigation or not. Just like Supreme Court or even for our High Court, criminal law is set in motion even in absolutely private disputes. Pure private disputes, criminal law is set in motion. You have a contractual dispute. I have supplied you books, you did not make me payment, you file a case. What case? You have committed fraud upon me, you have committed criminal breach of trust, and merely on the basis of two oral statement made before the court take cognizance, and cognizance is taken against the person who was in a contractual dispute. So, but ultimately, if that case is quashed by the High Court, and generally it is quashed by the High Court, that it is not a case of for the courts to take cognizance, and there is absolutely no criminal element involved in the present case. But what is the consequence? He has, at the highest, he has lost a case. But if he is able to get some relief before that, if the party becomes like he is threatened, that cognizance has been taken, warrant has been issued against me, police can come and arrest me, I have to take bail, a person who is doing business or any other person who is made to suffer this criminal case, he becomes afraid. That look here, I have been fastened with a criminal liability, I can be arrested, I can go behind bars, settle this matter. So that fear psychosis sets in.
Right.
And therefore that becomes a reason for misuse of the
this gives a message to
misuse
public.
For that. It is an abuse of the judicial process. But if ultimately if it is quashed by the High Court, then the High Court should direct imposition of cost upon the person who has indulged in filing frivolous cases. Because since this is not the consequence which is being made to visit.
Because the case completely falls into the criteria of frivolous.
Exactly.
Is there are two terms, frivolous and vexatious. So when a case is frivolous or vexatious, I think there's provision in both CPC and the current BNS Act that if you file...
It is called abuse of the process of the court, process of the court, or for the ends of justice, one can call.
Right.
But what was the point I was trying to make is that if it comes with consequences upon the person who has, because the other side suffers definitely. If you file a case against a person, be it state or the private party, he suffers, the other side suffers.
In one of the cases also that I saw you representing when I've read this case that you are representing, ethanol matter. So
this is a very recent thing which has happened. This is still sub judice. I will not speak more on it. You see, in fact, there are 2-3 cases of a similar kind. There is prohibition in Bihar, everybody knows. But there are a set of rules framed by the state government that transportation of alcohol is permitted under certain guidelines. Even if the same procedure is followed, you see, lodging an FIR is just an allegation.
Right.
The police will make an allegation which could be found to be false, that his intention was to sell spirit in the market. Even though it was completely in accordance with procedure. It was followed. It was under digital lock, which is the prescribed procedure. It was being transported on the route in which it was transported. The consignment was genuine. It started, the origin is established. Still, the police would seize it and file a criminal case against him, seize the tanker, seize the container. And in these two cases, what had happened? Immediately after seizure of the consignment, the origin of which is not at all disputed, that the origin was genuine, and the consignor and the consignee are well known. Like the consignor was a distillery situated in the state of Bihar, which is lawfully operating its premises, a manufacturing activity in accordance with law.
Right.
The government has permitted him to sell it, manufacture and sell ethanol, and the purchaser are our government companies.
Right.
Origin, the records show that the consignment started from its origin, that is distillery. Camera is there, the excise officers are posted at the distillery. The consignment started moving, it is about to reach the destination, it is seized by the police, making an allegation that they intended to sell the spirit. And we saw that this chamber was open, this chamber was not. You can always make an allegation. You can go and open the chamber, and right there the chamber was found to be open. Definitely, you can do that. And at the same time, you destroy you say that on the order of the district magistrate, we have disposed of the ethanol.
Without listening to the other party.
Without giving any notice to the other party. And that is of value. That is of huge value.
Huge value.
To the person who has manufactured it, to the person who is buying it, and even for the government, because this is a government policy, ethanol purchase policies of the central government, under which they are mixing ethanol with petrol so as to save foreign exchange. It is lost to the government also. But what they do, how they are destroying it is still not known.
And when the court came heavily on them?
And when the court comes, and ultimately the court passed an order imposing a huge cost upon them, and even directed for initiating departmental proceeding against the concerned officers. They filed that they took a decision. Well, what I was communicated that, why have you got cost imposed upon us? We would have released the tankers. We will now go to the Supreme Court. And they file an appeal in the Supreme Court merely because the cost has been imposed. So this is the mentality which
this is the classic example of the problem that we are trying to
canvas.
And they might spend way more money going for the appeal than they would have just given.
Yes, you are absolutely right. You see, filing a case in the Supreme Court and then engaging a senior in the Supreme Court, it costs like every date would cost around 5 to 10 lakhs rupees.
Right.
You will end up spending more than what you have been directed to pay by the courts. And there is no accountability on this. It is government money, it is coming out from public funds. Taxpayers' money is being spent on all these things without there being any accountability. True. So that is the problem. That is what I was trying. And you see,
think that is an ego?
You see, ultimately the entire judicial process is being crippled. Apart from monetary laws, you see, we are a developing country.
Right.
You see, many things have to be taken care of. People are still below the poverty line. We are still lack of infrastructure. We need electricity. We need roads. We need schools. We need hospitals. So we need a lot of money for all these things. But you are spending money on these things which are absolutely unnecessary and absolutely wrong on your part.
This
if an officer has committed a mistake or committed a wrongdoing, then he should suffer. Why should ultimately the government should suffer? Because they are entitled to take a decision to protect themselves. So,
and what is shocking for me is that even when cost is imposed in these cases, the cost is also taken from the public exchequer money.
Yes.
So in no ways these government officials are personally blamed for their...
you see, in fact, in many cases, court directs that the cost should be recovered from the salary of the person who was responsible. Even in such cases, the government files an appeal to protect them. But if there is an order that the cost should be recovered from the officer should spend money, the officer should file an appeal. Why should the government take up their case on their behalf and spend money for them?
They try to protect their own.
Them. Because you see what the problem is, ultimately they are the person who have to take a decision. whether to file an appeal or not.
Who is
so
a
it is
government
affecting them.
somebody.
They are the government servant.
Right.
So that is the problem, and it is crippling the entire legal system because of this situation. They are not following the litigation policy.
And also because of these cases, clients also lose hope with justice delivery system.
Exactly.
Like in this particular
there is a
case,
well-known, very old saying: "Justice delayed, it justice denied."
Yeah.
And you see the suffering which a person has to undergo.
True.
You see, state is like person which does not have any shape or form, but it is very powerful.
True.
And it has to be responsible for its actions. It should be responsible, and it should be very, like, decision making process should be very careful, and it should be very.
Like for me, this case shouldn't have gone to Delhi in the Supreme Court at the first place. It's a domestic case, should have been resolved here as well.
Here only.
That is where sometimes I question Supreme Court's power under Article 136, the SLP. It says in theory that unless there is a substantial question of law or abuse of justice, gross abuse of justice, such petition should not be entertained. But Supreme Court has also...
You see, the very wording of that is special leave to appeal. It starts with the word special, and then again it says leave. So special coupled with leave to appeal. So it should only be in extraordinary case. But unfortunately, it has become more of a routine manner. Even though Supreme Court is dismissing more than 90% of the appeals which is being filed on the very first date. But still, it is like, even filing an appeal should be stopped. Why should one file an appeal?
Right. I was reading, somewhere I read a report that 80% of cases that goes to Supreme Court is SLP. So people are...
it has become a appeal in the due course.
Right.
It has become an appeal in due course.
And again, every court is overburdened. So when Supreme Court is burdened with these cases, they can't do the job for which they are made.
Just to highlight this more, you see, our High Court, so far as Patna High Court is concerned, it is overburdened with criminal cases.
Criminal cases, yes.
There are at least, on any day, there are at least 10 judges, constitutional courts, hearing bail matters from Monday to Friday.
Which should have been resolved in trial court itself.
And the lower courts, they are not discharging their duties in the proper manner. Had they discharged their duties in the proper manner, High Court would have definitely not been overburdened with these cases, bail matters. This is not the constitutional courts, High Courts and Supreme Court. They are not meant for hearing bail matters. Only in certain cases when there is a bona fide dispute whether this person should be enlarged on bail or not.
It has become a matter of practice.
Lower courts are rejecting bail as a matter of course, and then High Court as a matter of practice has been granting them bail. I'll just tell you, if 100 case bail matter is filed, bail is granted in more than 90 cases. So if the bail is granted in more than 90 cases by the High Court, at least in 85 cases out of 90, lower court should grant them.
In these cases.
The remaining 5 cases should be it is quite discretionary that whether this is a fit case in which bail should be granted, that therefore High Court should entertain and such matters. But at least in 85 cases, had the lower courts entertained and exercised their powers, High Court would not have been overburdened. But that is an unfortunate part. Similar is happening in civil matters also. Like we have earlier we had only suits. Now we have commercial courts also. Because commercial courts invited attention of the central government, because with trade being liberalized, many countries had this notion that in India litigation is a very difficult thing. And once you land in litigation, you'll never be able to get out of it. Then they have this idea of exclusive commercial courts, Arbitration and Conciliation Act and all those things. But again, these commercial courts are lower courts.
Right.
Even if you have an arbitration award, execution is a very difficult thing. A person who, if he gets an award in his favor, he files an execution case. It takes years together for the matters to be executed, even though the intention is that it should be immediately be executed.
What is the explanation? Is there any explanation why?
You see, this is it is not a recent phenomena. According to me, that my line of thinking is that there is no set of law or set of facts on this. But my point of view is that what has happened, that only in order to detect corruption in lower judiciary and to ensure that the judges in the lower court, they act strictly within the framework of law and they do not indulge into wrong practice, the court started coming down heavily upon them. Even upon, and then secondly, what happened, there was another aspect of is that there were two parties in any case. If a favorable order is passed in favor of a particular party, the other party files a complaint before the inspecting judge or the high court that this judge has taken money and he has passed, therefore he has passed a favorable order. And a notice is given to him that this complaint has come against you, kindly give reasons.
In cases where discretion plays a larger role.
Plays a larger role.
Like
then,
in bail matters.
Then matters. You see, if there is there at that point of time, there was, the lower courts was kept under strict scrutiny. And then the judges also became skeptical that why should we pass orders, let us stop applying
so this
their
has
mind.
Set a wrong precedent.
So this had become a wrong practice, and then they started. But now things are improving. Now things are improving. They are given proper training. The judges who are appointed in the lower courts, they are given proper training. The process through which they are appointed, that has become very transparent and very fair. And we are getting good judges in the lower court also. But at the same time, they are given training also. But my advice to them would be that they should exercise their powers so that courts or high courts are not overburdened. Because it should be without any fear or favor to anybody. If, like, an oath is taken by a constitutional court that I will discharge my duties without any fear or favor. Similarly, they should also discharge their duties without any fear or favor. Then ultimately things would land in the...
Everyone should use their respective power and discretion.
You are there only for that. It is not that you are there only for your salary.
Right.
You are there for dispensing justice. People look upon to you. That kindly give us justice.
And sometimes, despite your best intentions, some omission will occur. So what?
You see, they pass a competitive exam to become judicial officers or become members of the higher judiciary. And that is a very difficult exam to pass.
It is.
They are being interviewed by members of the board who are sitting high court judges. If they are able to pass this examination, which is highly competitive, they definitely have merit.
Right.
They understand law and they have able to appreciate law. Therefore, they have joined this profession. They got this job, assignment of becoming a judicial officer. But still, if you do not pass any order, therefore there is a reason behind. You are understanding the problem. You are realizing that this should be the order which should be passed, but you are still not passing any order, which ultimately the High Court is passing. Because the High Court does not have any such fear. But they have the fear, therefore they are not discharging. So, but things are changing for the good. High Court is definitely asking them to exercise their power so that it is not overburdened.
That's nice to hear. Help me understand, how have you seen Patna High Court evolving through your 25 years of experience? You see, according to me, every institution since I had joined, like be it High Court or the Supreme Court, it has remained the same. It has not evolved as such. Number of cases has definitely increased. Litigation has become more costly. But judges were there at that point of time. Judges are there. Judges are at this point of time also. Lawyers, senior lawyers were also there at that point of time. Here, this time also we have senior lawyers. Quality, definitely it varies from time to time. Quality and perceptions.
Perceptions definitely varies from time to time. Earlier, like during our time, we had some senior advocates who were regarded more than the current set of senior advocates. Similarly, we had judges who were regarded more than the current set of judges who are regarded at this point of time. So it is always variable. You see, time will come that Patna High Court will have some good senior advocates who are much better than those who were there earlier. Similarly, it could happen with judges also, that we'll have some set of judges who are much better than those judges who were there at an earlier point of time. Like in Supreme Court also,
Right.
we had great judges, great legal luminaries, even at the bar, even at the bench. So,
So the perception of lawyers or justice delivery system since you joined the bar and today, has it changed? Has it become better, or it's the same?
It is the same. It is the same. It is the same. Only difficulty which I have seen, which should be taken care of, apart from the courts being overburdened with litigation and getting lesser time to decide any dispute. Another problem which has crept in is that in a given matter, like if you find case laws, you will get many case laws on that issue which is either for or against. So it becomes difficult for the courts, also for the lawyers, to take a conclusive decision that on this set of facts, this is the judgment or this is the law. It cuts both, it has started cutting both ways. And the reason for that is that judicial discipline or following the precedent is not being practiced. So had this phenomena not crept in, if there was already a judgment on a point of law, a court, he can easily escape from it by saying that in that case the facts were different, or the court did not have an occasion to consider this, therefore it came to the wrong conclusion. So this is not the manner in which, therefore this has resulted in many points of view on a given set of facts.
Uniformity
is not there.
I was having this same conversation with Mr. Mrigank Modi, and he said that High Court has become a punter's game, and Supreme Court has been saying that.
I will not say to that extent, because you see, there is another set of principle that a case is an authority for what it decides. That there is another point of view also. But at the same time, there should be consistency.
No, he expressed the same line of opinion. I agree. Today, if you try to find a judgment, you will find a judgment on cow, on grass, on everything. And if the judge does not have to be agree with that line of opinion, the judge could always say that it is not on the same facts and everything. So at the end of the day, when I asked him about doctrine of precedence, what about these theories, he told me that it has become a joke. And I mean, it is in theory, what you learn in law school and everything, that there has to be some uniformity in the cases, and the doctrine of precedence is there for precisely for that reason. But in practice, things are different. So how do we reconcile is the question.
You see, that is what I was trying to point out. Instead of going to that extent, because you see, there should be some discipline maintained. Consistency should be there. You should follow the precedence which has been set. You should not just overrule it yourself. If you think that it should be decided differently, then there is a procedure laid down by the Supreme Court and by the respective high courts also. You have to request the Chief Justice to constitute a larger bench, or the matter to be placed, if it is a single judge, then it is to be placed before a division bench. It has, accordingly, there is a procedure for everything. You should simply not say that I do not agree with this point of view because the court has not considered this. This is not the correct way, because it leads to too much of aberration in the judicial process, and what doctrine of precedence also.
Through this one prohibition case, on the first discussion that we were having, we were talking about legal reforms. So how policy making is done?
You see, this is a very interesting thing. You see, definitely without any iota or doubt, legislature is supreme so far as lawmaking is concerned. They are there to make laws, and it is binding upon all the citizens of the country. But the manner in which laws are made, you see, I'll just give you a recent example, that the WAF law, which was amended by the parliament, there was entire procedure was followed. You see, A draft bill was prepared. It was circulated for public opinion. Opinion of the people was taken. Their point of view was taken. The matter was referred to some committee. And like similar was the thing, amendment in Advocate Act was also initiated. And then opinion was taken, advice was taken from Bar Council, all stakeholders. And there was serious objection to this. They ultimately sat down and they decided that there is a flaw in that. They did not come out with that. But WAF Act also came with certain changes. So there is a procedure prescribed so that every stakeholder is taken into confidence and their point of view is also considered. And it is like well considered legislation, whether it is an original legislation, whether it is an amendment. But at many times you see what the situation, what has prevailed in this country is that like every state government, there is a ruling party. If they want to bring about a law, every member of that legislative assembly, he is bound by the decision of the party.
Whip is issued.
So a draft law is prepared. They have to say that yes, we agree to this, and then by a majority, it is enacted.
So law making is basically leader driven.
Leader driven with some members of the bureaucracy and all those things. And you see, just like in prohibition, you see, on 5th April 2016, prohibition was imposed by an executive order. By an executive order, prohibition was imposed.
No consultation, no debate,
consultation,
nothing.
Even the legislature was not taken into consideration. And you see, it impacted the entire state, not only the citizens, all the citizens, persons who were carrying liquor at that point of time, they also became criminals. Because by a stroke of pen, without there being any prior consultation, without there being any public opinion sought, prohibition was imposed. Our entire business was shut down. In the huge industries which were given protection against under the industrial policy and were promoted. You see, distilleries and breweries were promoted industry under the state government policy.
Right.
And they were asked to shut down immediately by a stroke of pen without there being a legislative act. So the legislature should also be very careful because you see the principle which the court is following is that even if you are challenging a legislation, there is a presumption in favor of constitutionality of that legislation. So if there is a presumption in favor of the constitution, the burden is casted upon the legislature. That before coming with my point, this is my point of view. Ultimately, legislature is supreme. They have to enact laws for us, and they are the best person to decide what is the best for the entire citizen, not for an individual. But still, before bringing about any law, they should take public opinion. They should bring it to the notice of the ordinary people so that objections are invited, all the stakeholders are concerned. Then it should be a well-considered legislation. Right. It should not come overnight by a stroke of 5-6 persons sitting together and deciding that like, yes, we should enact a law. That it becomes a decision of a group of persons. Instead of becoming a decision of the entire legislature.
No, this is a classic example of perversity in lawmaking.
Exactly.
Because just by this stroke of pen, High Court has been flooded.
You see,
with excise matters.
You see, what was did they do any exercise before imposing any prohibition? Was there any impact study? That what would be the impact of this prohibition? Forget the revenue aspect. The state government is very rich. The government says that we have enough funds. I'm not talking about revenue, but what was the impact upon the entire society? You say that if we impose prohibition, we will ensure that people do not indulge into consumption of liquor. They do not become an intoxicant. Very true. It is one of the constitutional principles also. But what is the impact? Ultimately, you see, we have created a parallel economy.
Right. Everybody knows in Bihar that prohibition is a joke.
In Bihar that what is the effect of prohibition. So, and the impact which has, the situation which has emerged, the courts are flooded with cases, 40-50,000 cases only in excise matters every year. More than 5 lakhs criminal cases are lodged in excise matters over a period of 10
So in the
years.
law-making process, this also has to be taken into consideration.
Exactly. And particularly when there is no prohibition in other states, except for a couple of states. In Gujarat, we have imposed prohibition since independence.
So there's a lot of academic studies to that regard, that prohibition does not work at all.
You see, ultimately you can take a particular decision, but my point of view is that it should be a well-considered decision. It should not become a whim of a particular individual that I want to take a decision merely because I am all-powerful, I can take a decision. That should not. This does not happen usually. It should not happen.
Very interesting.
Like I'll just tell you, like even we have courts, we have division bench, we have full court, 3 judges, 5 judges. Even in Supreme Court, we have 11 judges, Constitutional Courts, 9 judges. So every judge has to take his own individual decision after hearing a case, and then by majority take it. Does this happen in legislature? It does not. Yes, they definitely say that yes, we agree to the law. But is there any discussion? Are they asked individually why they do they want to have this judgment? There is no reasoning. So therefore, there is a lot of responsibility upon them before enacting a particular law.
What would be your advice to a law student who is confused between choosing a career in the practice side of law or corporate side of the law?
It is ultimately, it is your personality which matters. If you feel that, you see, both independent practice and corporate practice both are totally different things. Totally different things. If you are joining any corporate or even if you are joining a law firm, you lose your independence. You are directed by a set of people that you have to act in a particular manner. You are always like, yes, agreed, even if you join as a private practitioner, you are junior to someone, you are guided by. But still you are independent. You can take your own decisions whether I have to continue with this or. But if you are joining any corporate, so you are always given directions you have to follow. But if you have that point of view that yes, I am willing to follow directions, I am willing to act in a particular manner, then corporate is also good.
So if you are someone who values independence and autonomy, then practice
like you see, being self-employed and being an employed person, both are totally different things. So if you are willing to have that bent of point of view, then corporate is also good, not a problem.
Very interesting. In the end of the podcast, we have a segment where I ask a question from our existing guests for our next guest. So last time we had Mr. Avinash Srivastava, and he has a question for you. That I mean, he did not know that you would be the next guest, but this question, I'm going to ask a question from you as well. So the question was, what has been your approach towards this profession, to contribute towards delivery of justice or to earn livelihood?
My approach had always been to contribute towards the ends of justice. And still I am striving for it. Because livelihood was never a problem for me. I was quite fortunate enough. Though my father had a very humble background, but during his years of practice, he had earned quite a substantial amount so that we could be taken good care of. My elder brother is also doing good. So for me, it was not a livelihood thing. But ultimately, that it comes from within me that it should be for the ends of justice. And one should be very dedicated, one should be very focused in this profession. We should not transgress within, we should be very fair and very honest. We should never transgress. That is my point of view.
I really like this question in a way that this made me thinking that both are equally important. Like the delivery of justice part, that is the nobility of the profession, where you have to be honest to your client, to the court. And
you see, because I'll just tell you, livelihood, the quality of cases which I had handled on the private side, it made people to think that I had earned quite a lot of money, you see. But they are not. But I used to charge very less. Till today, compared to other lawyers, I still charge a reasonable amount from my clients. I do not file try to be exorbitant or being costly for them. So therefore, it comes natural to me. I want to do more cases and charge less. That is my point of view. That it was never a livelihood thing for me. Yes, agreed. I will try to charge fees and will take
livelihood is equally important.
It
so
is
you have to balance.
But you see, the balance tilts in the favor of ends of justice. Given both the situation. Like if it is only for money, then I would not leave a case.
Right.
That is my point of view.
Right. Very interesting. Thank you for agreeing to do this.
Thank you very much.
Learned so much from you.
Thank you very
much. I hope you enjoyed doing this.
Yes, it was a wonderful evening with you.
If you have enjoyed listening to this conversation, please consider supporting us for more such interviews. Thank you.